1.8 Constitutional Interpretations of Federalism. So when making the Constitution, they kind of wanted the state government to have more control over things that were happening in people's lives on a daily basis. And this idea of federalism and national versus state governments is heavily ingrained in the Constitution. So we're going to talk about the Constitution and federalism. So constitutional definition of federalism. We're going to talk about federal power. So we know, article is just talking about Congress, what it is, what it's doing, etc. It is almost half of the entire Constitution, so it's very long. And in Section 8, they talked about enumerated powers. So this is a limited list of what Congress can do, which includes tax, borrow money, raise an army, create a postal system, address piracy on the seas, define the immigration and naturalization process, etc. Commerce Clause means that Congress can regulate commerce between states and also between the U.S. and other nations. And then the last clause in Section 8 is the Necessary and Proper Clause, aka the Elastic Clause, which means Congress can make all laws that are necessary and proper. Basically, it gives Congress implicit powers. So basically, they can do more than just what's in the enumerated clause, so long as it's necessary and proper in our country to do so. So, Congress has that flexibility. But then Section 9 is no, this is what you cannot do. So, they can't tax exports. They can't take away habeas corpus, which is the right to be formally charged after an arrest. Can't pass bills of attainder, which are legislative acts declaring one guilty of a crime, and cannot create ex post facto laws, making an act illegal after one has committed it. And those were all book definitions. Oh, they also can't give titles of nobility. None of those words were bolded, but if you want to know them, they could probably be helpful, I am sure. And then Section 10 is what the states can't do. So states can't make treaties with other countries. Now, the states, and we're going to talk about the 10th Amendment. That basically is this is the federal government and this is the state governments. And the state governments can do all the stuff that the federal governments aren't doing. Also called delegated powers or expressed powers are the ones that the federal government have, that the Constitution says that they have. Whereas these reserved powers, the powers of the states, aren't listed the same way in the Constitution. They basically entail anything that wasn't given to the federal government. And of course, last chapter we talked about concurrent powers. 14th Amendment. This was after the Civil War, and its intention was to protect freed slaves. Basically, U.S. citizenship to anyone born or naturalized in the U.S. It also requires states to guarantee privileges and immunities, talked about that last time, to its own citizens as well as those from other states. It also has an equal protection clause, which means that state governments can't deny people equal protection of their laws when the people are within their jurisdiction. A lot of that was taken directly from the book. Page 67, and a lot of that, it's very straightforward. You get to know a lot more about the Fourth Amendment later, but if for at this level and through the book, I would stick to what it says on the page, and I would just stick to knowing and understanding that at the moment. So citizenship, privileges and immunities to own citizens, as well as obviously the other states, which we talked about in topic 1.7, and then equal protection clause. Now, the Supreme Court shaping federalism. McCulloch v. Maryland. Dun dun dun. Must know Supreme Court case. The question: does the federal government have implied powers and supremacy under the Necessary and Proper Clause and the Supremacy Clause? So does the federal government have powers that aren't specifically stated because of the Necessary and Proper Clause, which allows Congress to do anything necessary and proper, as well as the Supremacy Clause, which is federal law over state law? And they were yes, for McCulloch. So basically the federal government, they had this bank in Maryland, and they were wait, can you guys make a bank? Because the Constitution doesn't say that you can just make a bank. And so they were Maryland was okay, we're going to make your bank pay an insane tax so you guys go out of business. because, like, we have the authority here. Like, this isn't our state. It's our state's authority. But then McCulloch was like, no, I'm not going to pay that tax. And so they took it to court. And they were like, okay, Article 1, Section 8. It had phrases like coin money, borrow money, collect taxes, laws on bankruptcy, punish counterfeiting. So, like, banking is the federal government's business, was, like, their conclusion. And so, therefore, underneath the necessary and proper clause, yeah, this bank's constitutional. Like, they're allowed to deal with money and do this stuff. And it was a unanimous opinion. So, basically, this case was like, now there are implied powers in the Constitution. And since this case, the Commerce Clause has also been used for Congress's authority over, like, other commercial activity. So, like, all the money and buying, selling, trading, etc. Commerce Clause has been used a lot. You'll see that in the other cases as you go through. Now, dual federalism and selective exclusiveness. So the system of dual federalism is like national government. In the sphere of the national government is superior. But with things concerning state governments and state government activity, state government is like the superior. So in their own sphere, the federal government is superior and supreme. In the state's own sphere, the state's government is supreme and, like, superior, and, like, they reign above all. Like, does that make sense? Okay, so, like, on commerce, Congress can legislate on commerce, like, among the states, but the states can still regulate commerce within their own borders. So, states still have certain rights over commerce, which rejects, like, full national government authority over, like, trade and any commercial activity. And, like, this kind of idea is known as selective exclusiveness. So, like, Congress may regulate only when the commodity requires a national uniform rule. Taken straight from the book. So, Congress is limited on what they can regulate. Although Congress did try and get more and more interested in legislating, like, business and commercial activity, which, again, you'll see as we progress. National concerns, state obligations. Society was changing. The nation was growing, people were becoming more mobile, and everything started to, like, travel across borders. So a lot of the things, like, that the states once had was now becoming a national, like, problem or situation. And Congress just started to rely on this, like, Commerce Clause to regulate and reach national goals. This lists decreasing crime, making the workplace safer, and ensuring equality among citizens. Now, the Supreme Court stretches the Commerce Clause. Supreme Court was conservative late 1800s, early 1900s, and protected corporations and individuals with the Constitution. So it, like, questioned all the health and safety regulations that were being enacted. So, for example, Congress passed this law that said a company can't hire and force children to work in factories, and the Supreme Court was like, no, that law is not valid. Because that has to do with, like, manufacturing, not commerce, and so child labor, Congress doesn't have the authority on that. So with a lot of this stuff, there's this back and forth between, like, Congress and the court. And the Supreme Court case for the child labor was Hammer v. Dagenhart. Not bolded, but nice to know. Now we're going to move on to United States v. Lopez, another must-know Supreme Court case. The question, does Congress have the authority under the Commerce Clause to outlaw guns near schools? And the answer was no for Lopez, 5-4. Before this, Gibbons v. Ogden, that broadened the authority of the federal government to control commerce, is what it said. Basically, like, the government was able to control more through this Commerce Clause with Gibbons v. Ogden. Anyway, Congress passed this Gun-Free School Zones Act because they wanted to prevent gun violence, like, near schools. Lopez, this high school student, had a gun on him, and when he was arrested, he challenged the ruling to the Supreme Court. Basically, like, federal government doesn't get to regulate behavior at a state-run school. The United States was like, though, guns and drug dealing and all those connections, that puts it under federal jurisdiction and commerce power. But the court was like, Lopez is right, because, like, how are we going to put any limitation on federal power otherwise? Like, the states need to keep the authority for this. There are also some different opinions you can read through, but since the case, Congress revised the act so that it is much more tied to interstate commerce and therefore, is legal, but then also they don't give funding to schools who don't follow gun-free zones for schools. Commerce Clause continues to be challenged. Similar case is Violence Against Women Act, in the way that Congress used the Commerce Act, Supreme Court shut it down. I hope you learned something. Thank you for watching.